Well, to me, the most difficult thing that we have to deal with is the diminishment of phytoplankton in the sea. So since 1950, there's been a 40% diminishment of all phytoplankton across the world's seas. Phytoplankton provides 70% of the oxygen we breathe, sequesters enormous amounts of CO2. This is a serious problem because if phytoplankton disappears from the ocean, we die. We do not live on this planet without phytoplankton. And why is phytoplankton being diminished? Because of the diminishment of whale populations, seabirds, fish populations, marine mammals. And why that is because these creatures provide the nutrients that are required by phytoplankton, primarily iron, magnesium, and nitrogen. So diminishment of that biomass causes a diminishment of probably the most essential group of plants on the planet, which is the phytoplankton. And unfortunately, most people are unaware of that.
Can you go into some of the situation of why the way you portray things out on the ocean, which is something that I guess is obvious, but really hadn't occurred to me. It's just the Wild West. Like there's kind of nobody in charge out there, right?
It is the Wild West. We have all the rules and the regulations to protect the ocean and life in the ocean, but there's a lack of enforcement. For instance, after 50 years, they finally got around last June to passing the High Seas Treaty on the protection of biodiversity beyond national jurisdictions. Great, but it's a piece of paper. It means nothing because it hasn't been enforced and nobody's enforcing it. And in fact, the only enforcement of any of these regulations has been by NGOs, primarily ours, to go out there and directly intervene, to physically intervene. And towards doing that, back in the 70s, I formulated a strategy which I call aggressive nonviolence, which is to aggressively intervene but without causing injury and to operate within the boundaries of the law and of practicality. And over all those years, we've been very successful, well, without being convicted of a single felony crime or losing a civil lawsuit. But we have shut down hundreds of illegal operations.
Before we get into all of that, and that's what we really want to talk about, I just want to go a little bit more into this legal situation, a little bit more into what the High Seas Treaty does, but also, I mean, most people listening, myself included, really don't know anything about all of the treaties. We just think there's things in place. Can you go a little bit more into, maybe Sarah, you could do this like a really concise analysis of what the law is, how it works, and if they were the laws that if they were enforced, as Paul is talking about, what would they do?
Yeah, absolutely. So when we're talking about the high seas, it's certainly not incorrect to refer to it as the Wild West in terms of the law. I'd say up until very recently, with, as Paul talked about, the inception of the High Seas Treaty. But prior to that, we didn't really have any kind of major piece of legislation that was governing the high seas in terms of protecting biodiversity. We had a few ad hoc laws and treaties. For example, the International Whaling Commission had the moratorium on whaling, and certain sanctuaries and areas were protected. But of course, none of those laws, even those sort of bits and pieces that we used to have, were enforced, other than, as Paul has basically said, by the work of NGOs. But now we have the High Seas Treaty, which is, on its face, a fairly comprehensive piece of legislation that addresses this idea of the high seas being a global commons and does attempt to regulate it in some way. But it is, I think, a very ambitious piece of legislation, and what it will require is, much like, all of the other international treaties that we have, an enforcement mechanism. And so my wish with this, of course, is that it would put in place a framework for enforcement. But what I fear is that it might actually do the opposite and perhaps create a sense of closure from people who might think, okay, we've created the High Seas Treaty now, and that's the finish line. Because that can tend to happen sometimes with international laws where, we have a group of countries or the Conference of the Parties getting together, and there's a lot of patting on the back about something being created and then not really looking at how it's put into practice. So, I'm happy to get into some of the specific articles in the High Seas Treaty because some of them do provide sort of mechanisms for further NGO participation, but there's also articles in the High Seas Treaty that kind of undermine the entire treaty itself. So it's comprehensive, but on the other hand side, complicated, like much of international law can be. So
And speaking of which, we do want to hear about the specifics of that. We'll get to that in just a moment. But speaking of how complicated it is, Paul, something that has always struck me about your work is that you've often made this very point that you are not violating the law or making up what you think should be the law, but actually enforcing the laws that are on the books, but being ignored. Is that about right?
Yeah, that's absolutely right. We're not a protest organization. We intervene against illegal activities. For example, whaling has been illegal since 1986, and the Japanese, the Norwegians, and the Icelanders continue to do it. In 2014, we managed to get this into the International Court of Justice, and their ruling was that Japanese whaling was illegal. Yet it continued. So the problem is they just the countries that are involved just ignore the law. And the other problem with the High Seas Treaty is that it's been ratified by, well, the 60 countries at least that were required to ratify it, but only France and a few other larger countries, mostly they're smaller countries. Certainly the United States and other countries have not ratified it. And right now, the United States wants to go ahead with deep seabed mining, and which should be illegal, but they're just going to do it because they don't recognize the law.
Paul, tell us about the role of the World Charter for Nature in establishing the legal right to do what you do.
Well, I think Sarah could probably elaborate on that more, but it was passed in 1986 by the UN General Assembly. And do you want to elaborate on it, Sarah?
Yeah, absolutely. So the UN World Charter for Nature includes Article 21, which does actually grant private actors, civil society, the ability to intervene to protect global commons and areas that are at risk. Although the provision itself does, when you read it on its face, seem to grant this authority, though, the issue is that the UN World Charter for Nature is not considered binding. So it does, in some way, create a customary law, but this is not a treaty that many nations, have ratified or considered binding. But the argument that, I make in the book is that it does establish a norm for non-state actors to intervene in this way, and not only establishes it, but in some way calls for it as well. So
And even when countries where it is binded, for instance, in 1995, I chased the Spanish drag trawlers out the Grand Banks of Newfoundland. I was arrested by the Canadian government, charged with 3 counts of mischief. My defense was the UN World Charter for Nature. Well, Canada brought a law professor from Toronto that said it had no application under Canadian law. And the judge says, but didn't Canada sign this? And she says, yeah, but Canada signs a lot of things. So basically, he advised the jury to take it into consideration, and I was acquitted of the charges.
Yeah, I'm really sorry for laughing, but God, sometimes you just really have to. But I think, I just wanted to take a moment to clarify for people why this book is so extraordinarily important. I was saying this to Paul before we started recording, that I think this book is absolutely vital because it sounds so far that we're just talking about, we're going to sort out what all the laws are and talk about a few adventures. That's not what this book is about. This book is about how we have to change the way we look at the law of the sea, and most significantly, how it is enforced or whether it's enforced. And these are very new, very radical ideas that are desperately needed. And one of the things, obviously, that you do is challenge the assumption that only nation states have the authority to enforce laws, which is a pretty radical assumption. But it kind of begs the question of who else has the authority. Like where does that authority come from? So what are the elements that might provide legitimacy to a non-governmental entity like the Paul Watson Foundation that claims to be enforcing the law, and other people think they're not, and that's basically the conflict that I think has been the basis of Paul's work his whole life in some ways. And you're really trying to get it down onto paper, like what's going on here. Is that right? And so where does that legitimacy come from?
the concept of legitimacy in the book is treated as sort of an outcomes-based legitimacy, not legitimacy that comes through, let's say, having authority granted formally, like to a nation state. But the way that I conceive of legitimacy in looking at this issue of high seas enforcement is who is the most effective actor. And what I establish in chapter 3, especially looking at the history of international environmental law, is that nation states have been successful at creating frameworks and creating norms, but they have consistently failed to enforce them. And that there's really only one actor, which is non-state actors, and at that, a very small group of those non-state actors who have been successful at effectively enforcing these laws and doing so in a number of ways, at times actually working at the behest of the state, sometimes working alongside Interpol, but yes, sometimes working independently.